10 seconds, 5 seconds, start. That apart, the liquor license which the respondent was required to procure to operate the bar in the hotel could only be procured in the month of May 2019. That apart, he stated that there is a failure of the part of the respondent to pay the management fee. He highlights the fact that as on July 31st, 2020, the total outstanding amount towards the basic management fee and the incentive management fee is a sum of rupees 2 lakh, which is required to be paid along with interest at 2% per month as per Article 12.4 of agreement. The Learned Counsel submitted that the petitioner was shocked to receive an email purporting to terminate the agreement owing to alleged poor performance of the hotel in terms of generating revenues. The petitioner issued an immediate response to the email inter alia, bringing to the respondent's notice that the purported termination was unlawful owing to the lock-in period of 5 years in the agreement. The petitioner also highlighted how the failure of the respondent to provide essential facilities like swimming pool and liquor license has affected the revenues. Thereafter, the parties had discussions during which the petitioner asserted and examined that the lock-in period of 5 years would commence from July 2017 being the opening date, and the lock-in period would expire only by July 2022. The petitioner was shocked to receive a letter through email purporting to be another termination notice from the respondent. The respondent repeated the false contents of their previous communication and completely overlooked the facts stated in the petitioner's reply. Unfortunately, overlooking all the pleas taken by the petitioner, the respondent issued letter whereby the petitioner terminated the agreement executed between the parties. During his submissions, the Learned Counsel has drawn my attention to various provisions of the agreement to contend that Article 24 of the agreement prescribes the term of agreement to be initially 15 years starting from the opening date, renewable for another 10 years, with the first 5 years of the said term to be the mandatory lock-in period of 5 years, which would thus be commensurate with the starting of term of 15 years. Admittedly, the opening date being July 2017, the mandatory 5 years lock-in period would start from July 2017 being the commencement. He has also drawn my attention to the definitions which are depicted in Schedule 1 to the agreement to contend that the effective date has not been defined in the definitions. The words effective date mentioned in Article 24.3 have to necessarily be read with the earlier part of the same article, that is, first 5 years of the terms of contract. Hence, the effective date has to be read as the opening date, since the term starts only from the opening date. Otherwise, reading effective date in the manner urged by the respondent would render the first part of the clause, that is, first 5 years of the terms of contract, as notice redundant.